sir, and welcome to the IPTSE Podcast series.
Namaskar,
Namaskar.
Hitaishi ji.
Yeah.
How are you?
All good, sir. Thank you. How about you?
Fine, perfect.
Yeah. So, sir, you have been a civil servant, and we would like to know as to what was your role as a civil servant, also your non-work interests and your hobbies, just to start with.
Oh, okay. I took civil service examination in 1988. That is UPSC civil service examination. And I got the Group B services, that is called CSS, Central Secretariat Service. And worked in the World Bank division during the Manmohan Singh ji, who was finance minister, and P.V. Narasimha Rao sir was prime minister. And it was a learning experience, the World Bank aid and various projects. The project monitoring and implementation, that was the things I learned it, and that helped me throughout the life. Then I became Undersecretary in Information Broadcasting, where I worked in Prasar Bharati Board, the first secretary to the Prasar Bharati Board. So I set up the board meeting procedure, I prepared the rules, got it approved, and just started like that. And both All India Radio and Doordarshan I worked, and then came to information broadcasting. There I got the tricks of the trade of major policy making, because I was sent to do the MA in Development Studies, Public Policy Management. That helped me to understand all the tricks of policy making. And then came back and tried to implement whatever knowledge I gained at the ground level. And it was there I got introduced to the copyright. At the time in 2005, November, this WIPO broadcasting treaty discussions started. And then that opened my
interest
in that, and then started learning. And Mata Saraswati ji ka kripa hai, and she put me in the copyright office as a registrar of copyrights, and there I become deputy secretary to undersecretary, director. And entire history of the copyright office, 6.5 years I spent there. And that was the most happening time. Not only the amendment to the Copyright Act and addressing the various burning issues at the time, and whether it is authors, music composers, performers, statutory license, and improving the functioning of the copyright society, and most importantly, which is most dear to me, the exceptions, copyright exception to the visually disabled and physically disabled.
Yeah, the Marrakesh Treaty. I
That
guess
we took it to Marrakesh Treaty, and has strengthened when even the many developed countries were opposing, because it's first of its kind. All entire intellectual property ecosystem, it is a protection of rights of creators and inventors.
Yes,
Here we are
definitely.
giving exception to the copyright on the basis of human rights angle for the visually impaired. So we succeeded not only India, and best practices we exported there. And similarly, we exported the transfer of rights concept. We introduced the right to receive royalties for the authors, composers, and extended it to performers, and exported in the Article 12 of the Beijing Treaty. You can see the entire Indian language. That's what we have written.
So just for knowledge, till then this royalty and everything, do you mean that was just taken up during that time only, or earlier it wasn't there, or how was it?
It was there, but there were some administrative problems in the IPRS society. The Copyright Society for Online Works, Authors and Music Composers. And then the 93 agreement was there, signed by both music companies and the author composers, headed by the then great music composer Naushad ji. But from 93 onwards, it was working, sharing of royalties, whether a song is broadcast in a radio or hotel or any other public performance. But unfortunately, there was some internal politic happened. A group of people were denied. They were asked to give in writing that they don't have rights. The question came: if they don't have rights, why are you doling out 50% royalties? Underlying words.
Yes.
So that is the international business model, and we introduced a lot of people opposed it. Entire Bollywood and also South Indian film producers basically, and we have to make them understand that nothing new we are introducing, but it's already in the practice, which got some hiccups, trying to remove those hiccups. And the entire CSAC, the Confederation of the the performing rights societies all over the world, 124 countries, has more than 240 registered societies like our Indian Performing Rights Society. And when complaint went to the then Principal Secretary, to the Prime Minister, that is Manmohan Singh ji, before discussion in the Rajya Sabha, it was pulled out, the bill. And the then Minister Kapil Sibal ji sent me, go and explain to the then Principal Secretary, and I explained him. I gave him only an example that it is in practice, so many countries. I carried the executive summary of the CSAC report, fifth term. And 2 weeks back only the CSAC latest report has come, 2022. And it was the report of 2011 I carried. The humongous work was going on at the time. The 7 billion euros, that is 50% royalties, were distributed to authors and composers across the world in 124 countries. So all this data, when I gave it to Sri Pulok Chatterjee, IAS, the then Principal Secretary, and then he cleared that. And I know the celebrations after that, unanimously passed by the both houses of the parliament. That was the greatest experience as a civil servant.
And you felt it as an achievement, big achievement.
And also the extending the exceptions. I told him that, you can't be denying the right which is implemented all over the world, which the WIPO is supporting and all the national laws are supporting. Then, and by pulling out the bill, and you can't damage the human rights angle, which we are supporting by giving exception to the visually impaired people. That is we try to remove the book famine for visually impaired.
Okay.
And then move to the industry ministry. There I participated mainly in all bilateral treaties, FTA negotiations, and the most interesting part of multilateral, I was in charge of the Russia and CIS countries trade relations council, and the most important thing is regional comprehensive economic partnership agreement. The 5 sittings, I was the chief negotiator for the IP chapter. It had the other negotiators also taking care of other trade and commerce services issues, including competition law. But here I had to put all the interest, safeguarded, because the 10 ASEAN countries, including its trading partners, except India, was supporting the most dangerous treaty signed at the time secretively by the developed countries called Trans-Pacific Partnership Agreement, which were going TRIPS plus. Now, had India agreed, thanks to Sri Narendra Modi ji, and he made India withdraw from the RCEP agreement. Before COVID also, India was recognized as the pharmacy of the world. When this opinion was got reinforced during the COVID time, the way Honorable Prime Minister Modi Saab leadership mein, India gave vaccines to so many countries. That is reflected when the Papua New Guinea PM, the way he respected our Prime Minister, touching his feet. That is the thing which India did. All this would have gone, our entire pharma industry would have been destroyed, the jobs would have gone, and India would have been flooded with the same generic medicine from other countries.
Yes.
Forget about the patented medicine. So that is the great step we have taken, and other industries would have also served, especially the access to medicines, access to knowledge and information in education would have been damaged a lot had we gone with ourselves. That was the thing I did by putting everything in the square bracket negotiations, and got the red eye of many heads of nations there.
Right.
But nation comes
First.
first.
Yes.
Yeah,
And
that's
it is
what
so satisfying.
normally we civil servants are
Yes,
taught.
yes.
So that's what I did at the time. Nothing great, but it's a satisfaction
Yes,
that
very
something which we did, and finally PM also did his job.
Part, yeah.
Yeah.
Okay.
And then after that, I became joint secretary. Continued there only in the industry. Now it's called DPIIT.
DPIIT.
After a couple of years in central staffing, was posted in the Department of Justice. There again, the ease of doing business which DPIIT started. So I was given charge of enforcing contracts, improving the commercial codes which was set up under the 2015 Commercial Code Act. There also I tried to contribute a little because the commercial codes were not set up at the district level, because there was a mistake in the drafters when 2015 Act came, and then again I have to take initiative to get the Section 3 amended to introduce the district courts in Delhi and Mumbai, Kolkata, and Chennai, including the Himachal, that is the 5 courts where original jurisdiction is there, and the case has to go to even 3 lakh commercial dispute has to go to High Court. You understand how much money filing a case takes place, expenses, it will shoot up. It will go more than 3 lakhs. So recovery of 3 lakhs, you'll be spending more than 3 lakhs. So that was the reason we said no. In a small amount of dispute, a special district court has to be set up. Every 500 cases, one district court should be there.
Yes.
With all equipment
speedens up also.
and this staff separately. And thanks to the Delhi High Court always taking the lead and taking this decision, which was implemented across by other high courts. And another important thing is my suggestion of pre-institution mediation, which was mostly opposed at the time, left and right. And again, thanks to another principal secretary, Raghavender Mishra ji, he recognized my point in one of the meetings in that PMO meeting. And finally, that's done now, the
Okay.
pre-institution mediation, because it's, before you go and file a case for the commercial dispute, that can be, mediated, settled
Yes.
in a given time of 90 days.
Okay.
Yeah, and if and it's a dropout mechanism we introduced. So because all mediations to be voluntary, here we said an opt-out mechanism. If both parties, at least one
Agree.
party doesn't agree, you can opt out, and then the other party will be forced to file a case there. And also there a case management hearing, pre-trial conference introduced in Order 15A, amended CPC especially for the commercial courts, and that reduces in just one hearing exchange of list of witnesses and evidences, other thing, and framing of issues. So within the prescribed time of by the resolution of commercial court, that can be settled. And then again Delhi High Court seriously following this and getting the things done. Most of the IP cases, because the 21 varieties of commercial dispute, IP is the major thing there again. So that is another satisfactory contribution I did as a civil servant. And coming to hobbies, before I jumped to law and public policy, Mm, I'm a science graduate.
Yes, I did
Did
see
my
your qualifications.
first postgraduation in ancient history and archaeology
Yes.
and culture. I'm a gold medalist in that, and the first UGC net scholar. Did my MPhil, and I'm fond of going to ancient Indian temples.
Okay.
So post retirement, last 5 months, that's what I'm doing.
Traveling across India.
Yeah, wherever temple is there, ancient temple, go and see and enjoy. Try to brush up my knowledge, and that is the one thing. Second one is I'm fond of reading Upanishads,
Great.
the ancient knowledge.
Yes.
So that helps me to understand the philosophy given by my guru. I'm a follower of Sri Madhvacharya, the Dvaita system of philosophy we follow.
Okay.
And I try to understand what Madhvacharya ji said and relate it to the Bhagavad Gita and relate it to Upanishads and the Prasthana Traya, the Bhagavad Gita, Brahma Sutras and Upanishads. So what is this commentary? Why he said it is Dvaita, not Advaita? So that's my hobby.
Great, sir. That's so good to know. Okay. So you, I think you have already mentioned your stint as the Registrar of Copyrights. And could you just specially focus on the drafting of the 2012 amendment that was done?
Yeah, 2012 amendment, as I told you, we wanted to protect the already existing underlying works right for the authors, especially the lyricists of the film songs, music composers, and also the performers. And we introduced that concept of right to receive royalties for them. That is 50% when song is played out of the theater, that is cinema hall.
Yes.
Because entire copyright goes to the producer who is the author of the film as per the Indian Act. He takes the interest and takes the risk of completion of the film.
Right.
And then entire copyright goes to him. So, but when these songs are played independently, that's what the Justice Krishna here in his footnote, obiter dicta to the famous 1977 case, Indian Performing Rights Society versus the Eastern Motion Pictures producers, the judgment when Justice Jaswant Singh Ji just no right, all rights go to the film producer. He wrote in that the penumbral area of the copyright right law, the rights of these people, authors, composers, including the performers, has been neglected, and government need to do that. That's what we did it, and also we strengthened the functioning of administration of copyright societies, where we said that whether it is an author, a music composer, or a performer, they have equal rights with the right owners.
Exactly.
That imbalance was there, that we corrected. And one more, that we allowed performers to create their own society. Only singers, Indian Singers Rights Society has been done. So other performers like actors and others can come forward. And I understand that the script writers also filed an application, and there's a confusion whether it is a literary work and dramatic work.
Achha.
So I think that supposed to have been solved. Hopefully they will also get a registered society to administer their rights. And one more important thing is the Indian Reprographic Rights Organization. Apart from the IPRS, the underlying works society, Indian Reprographic Rights Organization, IRR, also re-registered. But unfortunately, the Delhi photocopy case decision stumped them, the collection of royalties. Because here there is even though I appreciate the judgment of the Delhi High Court, but there is a small question which always went unanswered. So once the society is registered, when photocopying happens, they have to get those who photocopy for the commercial purposes has to take a license. but the argument was that the universities do photocopy only for education research purposes. But humongous photocopy is happening. Even for the course packages, the argument went on in that case. That photocopy is done with this exception, which has been rightly explained. What is the legislative intent of providing this, and that's what the court explained. But as a student in the Law Center 2 of the Delhi University, when I paid some semester fee, I paid for the course packages.
Yes.
Okay, at least certain amount should have been gone to the authors and publishers. A university like Delhi taking a 50,000 rupee license per year.
It's a huge amount.
A simple amount, 50,000 rupees. They're not asking for you to take 50 lakh rupees or very any other high amount. 50,000 rupees license per year for a Delhi university is not that burdensome. and when you are charging from students,
Yes.
you're not giving them free the course package. I paid. I remember the semester fee clearly written. That amount there's a split into one. I think 350 or 450 rupees they charge. I don't remember.
Achha.
Course packages. If you show that receipt, then only
you
those
get
books
the
are
course
given to
material,
me every semester to read. It contained photocopies of many books, not only the case laws, with the copy edited case laws explained by the professor. Okay, we'll leave it at.
Yeah. Okay.
And then the statutory license issue for the broadcasting that was needed because the phase 2 of the FM radio was coming, and the information broadcasting that we got less applications because the section 31A gives compulsory license that is taking a lot of time. And if a statutory license comes, and many people in the type 2, type 3 cities also interested to start a FM radio. And because an FM radio without content, what is the content? Film songs, whether Hindi or regional film songs, if that is not made available, it not function. Unlike All India Radio, where they have the classical, Carnatic music, Hindustani and folk and everything. But here, it's not like that. Then statutory license concept is that it is introduced to help a fledgling industry for temporary time till it settles, and then that can be taken off. But it was introduced when it was introduced for radio and TV started creating problem. No, we also want it. Okay. And then I&B ministry opposed, and higher education department also opposed. But again, it wasn't allowed to be passed in the parliament. Okay. Unless you give it to, television, you will not get.
Okay, so radios were
So then, while browsing through the act of how to solve this problem, suddenly I stopped at section 52B, where the resale right is there. Resale right is a droit de suite, which was introduced during the First World War time in the French copyright law, that the painters, once the painting is sold, again resold, the huge amount, the original painter won't get. So this concept, they took it from the property law and introduced in the intellectual property law.
Achha.
That at least some percentage of resold amount has to be given to original painter.
Exactly.
So the concept we introduced in 94 amendments in India, section 52, resale right for the literary artistic works, especially manuscripts, sculpture and painting. So copyright board here fixes fee, different fee for the different works.
Okay.
So that up to maximum 10%. Then I took that concept and put it in the statutory right, rushed to the minister saying that this way we can. Then minister approved. We got it drafted and introduced in the act, saying that the kind of royalty radio is going to pay once it is set by the copyright board, same will not be applicable for TV, and a separate royalty has to be fixed for that. So that way. Now webcasters came. Webcasting streaming will not work. They can survive without statutory license. Look, till now the statutory license fee has not been fixed. Copyright board didn't do that, and later first tribunal reforms, it got matched with the Intellectual Property Appellate Board, IPAB. After that, IPAB also didn't fix the rate for the statutory license, and now it's been abolished in the second tribunal reforms. Now the entire work has been given to all the commercial benches of the 25 high courts. Now after that, Delhi High Court is working greatly because of the initiatives taken by Justice Pratibha Singh in setting up of the IP cell there, which has been replicated in the Madras High Court recently. But no one has approached, neither government or anyone, to fix the statutory license fee in the Delhi High Court, commercial bench, or any other high court. So for so many years, Act was amended in 12, rules came in 13, and after 10, 11 years, they are surviving.
Yes.
So if I take out the statutory license from the Act, because everyone wants, घोड़ा है तो ठीक से चलने वाला भी बोलेगा मुझे टांग में दर्द है, मुझे भी घोड़ा सवारी करना है. So that's what the webcasting streaming people are doing, trying to enter this. Sometime back, couple of years back, there was a mistake in DPIIT. They issued office memorandum saying that the broadcasting means the communication to the public by any means.
Okay.
By any means the concept it allowed webcasting also.
Yes.
So their interpretation they issued. Some inadvertently must have not read properly. Then people came to me that no, you see, in the clauses, in the subsection 3 and 4, and also the rules, only fixing this only for television and radio broadcasting. How can you extend it? So what is provided in the section 1 to the 31D has been taken away. I simply mentioned that broadcasting of literary works and sound recording, statutory license allowed. But you can't give that interpretation to definition to that word broadcasting. Introduce a new element in addition to what is given in the law approved by the parliament. Office memorandum can't make laws.
Exactly.
Yeah, parliament has to amend to introduce that 31D, and rules have to be amended. Then webcasting will get.
Yeah. So great.
So these are the things we did, and let's see how it works. And
Let's
then now the new
further.
problems have come, ChatGPT and generative
Yes.
AI.